In the matters 24 CF 245, 24 CT 102, 26 CF 31, State of Wisconsin versus Jason Belisle. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Belisle in person in custody with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. Mr. Davis, can you please recite the agreement that's been reached?
Sure can, Your Honor. Thank you. My client is going to be pleading to a count 1 possession of methamphetamine. All other counts and cases are going to be dismissed and read in. He's going to have a withheld sentence with 2 years of probation. The state was specific that they wanted an AODA assessment, and he must obtain his driver's license, court cost, fine, and DNA surcharge. And that, I believe, was the agreement that I received from District Attorney Schmidt.
Okay, and that's accurate, Mr. Vila?
Yes, Your Honor.
So I have in front of me a plea questionnaire waiver of rights form. Mr. Belisle, do you understand what this document is?
Yes.
Did your attorney thoroughly go over it with you?
Yes.
And there was nothing that was complicated or you didn't understand?
No, Your Honor.
And you, okay, so it states here that you're pleading guilty to 1 count of possession of methamphetamine. Is that correct?
Yes, Your Honor.
You are 49 years old. You have 12 years of schooling. You can read, write. You understand the English language. No mental illnesses or disorders. Is that all correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes.
You understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand, well, do you need me to go over those rights with you in any more detail?
No, Your Honor.
And with these rights, you understand by pleading guilty, you are giving them up?
Yes.
Okay. Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here the state would have to prove on or around March 10th, 2026, you possessed a substance, the substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalties could be a fine of up to $10,000 or imprisonment of up to 3.5 years?
Yes, Your Honor.
You understand that?
Yes.
Do you also understand that there is an agreement reached between the parties where you would plead guilty and be on a recommendation for probation for 2 years with certain conditions? Do you understand that I'm not bound to follow that agreement?
Yes, Your Honor.
Said differently, I could sentence you all the way up to the maximum possible penalty, and I could do so here today.
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Do you understand you're pleading guilty to a felony? You will no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in election until your civil rights are restored?
Yes.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, that section called the probable cause section, where it basically says what happened and why you were charged with the crime?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to the felony misdemeanor felony possession of methamphetamine because you're guilty?
Yes.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone, to find a fact, thank you.
I have not put any threats or pressure, Your Honor. I have not threatened or pressured Mr. Belisle, Your Honor, and I've gone through the plea form with him twice.
All right. And so no one's threatened you, no one's promised you anything, so you would plead?
No, Your Honor.
And so you're doing so freely, intelligently, and voluntarily, telling me you fully understand what you're doing?
Yes, Your Honor.
Has your attorney represented you competently?
Yes.
He's answered your questions?
Yes, Your Honor.
He's looked at this matter thoroughly?
Yes.
And you're satisfied with his services?
Yes.
Any questions for the court or your attorney before I proceed?
No, Your Honor.
As to count 1 in 26 CF 31, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up your rights. I will find a factual basis to accept that plea of guilt. Based on that, I will find you guilty of count 1. The only count, possession of methamphetamine. Judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation here is appropriate. Looking at Mr. Belisle's history, he has a long road of struggling with addiction. Given that, I think 2 years probation is appropriate to give him the tools and access to programming necessary to help him to continue to work on that path towards working on his sobriety. And giving the added layer of making sure that he gets his license would also address the OAR issue. Given that, I think the court should stress the rehabilitative needs here, and I would ask the court to adopt the joint recommendation. Thank you.
All right, Mr. Davis.
Well, I think any conviction is serious. However, I'm not going to waste my time. I think that this is a situation where the judge actually knows my client better than myself. And I've known Jason now for a lot of years. And so the only thing I can say is he is going to get back into treatment. I'm glad that he's decided to do that. Sometimes just the assessment and follow through is sometimes not adequate. And I think Jason needs to get back into a program, which I think he's going to do. As the court's aware, he let us know that he went through cancer. He actually had the surgery, but again, he's got his feet stuck in the mud and he's refusing to do follow-up visits for that, which he has to. And he's informed me that he's going to do that. And now he has not just his children to look forward to, but grandchildren, he told me. So he does have a life to live for. And that has to include no drugs and also no drinking. Has also been a plague on Jason for many years. He looks good now. He looks as healthy as I've ever seen him. And I just want him to be healthy, body, mind, and spirit. And I don't want him to be in the court because I don't want to represent him ever again. I don't want to have to see him in this arena. I'd rather see him out in public or in society. And, I'm not disparaging Jason at all. He knows that, but I'm just getting sick of seeing him here in an orange suit, being locked up because he has more of a life to live than just sitting in the jail. And I think that the 2 years probation is something that is required to keep him on track. And not everyone likes probation and they don't like having someone keep an eye on them. But in this situation, I think it's important for Jason to have that added layer and the public's protection as well. And I think the public will be protected if he's put on a withheld sentence. And I think the public will be extremely protected if he stays sober. And God willing, he can do that. So I hope that happens. And I really do hope this is the last time that I'm sitting next to him in court for anything involving criminal system in Wisconsin. So I think he's going to be successful, though. Thank you very much, Your Honor.
Thank you. Mr. Belisle, anything you want to add? You want to state to the court?
Yes, Your Honor. With the cancer stuff, it's been a hard road because I can't get over getting it, I guess. But I had the surgery, but I never went back, like Mr. Davis said. But I plan on doing that because I have a grandson now, and that kind of changed my outlook on things. But yeah, a work in progress.
Everybody's a work in progress, Mr. Belisle. Everybody is. Mr. Davis is probably correct, or he actually is correct. I probably know you far better than he knows you, just because, I mean, we go way back.
Yeah.
We both grew up in this community. We're both from around here, and we knew each other in school. I've said it before, and I'll say it again. The Mr. Belisle that I've known before, the Mr. Belisle that appears in front of me today and any other time, you're always so quiet, so nice and respectful, all of those things. And it's hard to see or actually understand, knowing who you present yourself as and the actual criminal convictions, black and white, that I see. Because it's like two different people. But it tells me that you have a substance abuse disorder, whether or not it's alcohol, whether or not it is methamphetamine or some other substance or multiple substances. It kind of scary, I'm sure, even for you to see that something could happen that that no one would like to happen unless you're able to take control of your issues and address the trauma that everything probably stems from. Hopefully you can do that, and I want to see you do that. Did you say how many days of jail credit he has? If it is a concurrent sentence versus consecutive?
Since the 10th.
Or
The 10th since March.
Yeah. 60 some days.
It's since March 10th. If I can do the math on that.
okay. Your cases are never really serious except if they were the OWI, the operating a motor vehicle, when you have something where it could be harmful. Otherwise, it's just, it's showing that you are harming yourself and not others. I'm going to do the 2 years of probation. Hopefully you'll be able to work through some things there. I'm not going to do a withheld sentence. I'm going to order 6-month imposed but stayed sentence if you are revoked. This isn't a prison sentence by any means. And honestly, this isn't even a full year or 9 months because you have a substance abuse disorder. Conditions will be absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Get your driver's license if you're able to, because I know there was a time a year or so ago that you did not think you would be able to ever get your driver's license back. And it has nothing to do with the OWI for permanent conviction or permanent revocation. No alcohol, no bars, taverns, liquor stores, or casinos unless it's employment related, or any establishment that has the primary purpose for the sale or the service of alcohol. No driving without a valid driver's license. And regular testing and any programs at your agent's discretion. $518 in fines and fees. The rest of the counts and cases are dismissed and read in, or they are.
Judge, I have 51 days.
51 days of jail credit. I think you owe other fines and fees to
Yes.
the county, or they're in state debt collection. So this will just be added to your normal payment plan. If you fail to pay, not only will the court enter a civil judgment against you, you're always going to owe that, but the court will issue a warrant. You could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. I'm ordering your DNA. You may request it be expunged through a written letter to the Department of Justice. Yours is already in the system, but you still can request that this particular case is out. I think that covers everything. Report to probation immediately upon release. What, anything that I'm missing?
Did the court already provide the rights to appeal?
20 days to appeal. I think I did. If you don't appeal within 20 days, you lose that right.
Yes.
Anything else, Mr. Davis?
No, Your Honor. Thank you very much.
Good luck, Mr. Belisle.
Thank you, Your Honor.
Actually see it. I want to see it here again, okay?
Christine, you don't have to come down, visit.
Well, come down and visit.
Mr. Strenke,
I'll take you for lunch if you come down and visit.
Okay.
Your Honor, it's a waiver. May I release my witness?
yes. We will go on the record in the matter 26 CF 20, State of Wisconsin versus David Strenke. The state appears through Assistant District Attorney Jose Vila in person. Mr. Strenke appears in person with counsel Emma Hanu. We're set today in this matter for preliminary hearing. However, I've been informed that it is a waiver. Is that correct?
Yes, Your Honor. This will be a waiver. An offer was extended that was contingent upon the waiver of this. Mr. Strenke does want to accept that. Normally, Your Honor, I would have had the preliminary waiver hearing done signed, ready, and not have wasted the officer's time by being here. But Mr. Stranke has been working on himself and does not have his own phone right now. So I've been unable to contact him until today.
Okay, thank you for that, Ms. New. Mr. Strinky, are you still in Spirit Lake Road?
No, I currently got a new place, but it's 2334 to Borg Road, Grantsburg, Wisconsin.
What road?
Borg, B-O-R-G.
Yeah, what was it? 2334.
Yep. Or no, 24432. Sorry. Yeah, it's kind of a tricky address, but
24432.
yeah,
Borg
Borg.
Road, Grantsburg.
sorry.
Okay.
It's a new address, but it's like I've been working on myself since I got out, and I figured changing my environment and getting on my own 2 feet, then it's the best thing for me. So I got out from where I was staying, and me and Beverly, we've been staying out there, and I've been doing a little bit of side work for the dairy and stuff, trying to get my foot back in the door there. So it's like before I jumped in head first with that, and I was working 80 hours a week, and it just kind of overwhelmed me. So then I relapsed, so then it's like I wanted to try a different approach now. So I figured starting out part-time, going into it that way, then I was able to get hooked up with a friend of mine that lives just up the road, and he works at the dairy as well. So he's been driving me back and forth to work. So
Oh, good. So you're change your environment to help change yourself.
yeah, so that's what I've been working on, and it's been working so far. I mean, I guess that's a work in progress, but gotta
Again,
start somewhere.
We're all a work in progress.
Yeah.
Okay, so we have that, but you don't have a telephone yet.
No, not yet. And
are you going to keep that old number you had, or totally different number?
I think I'm gonna keep the old number, but I'll let you know if I don't,
Excellent.
because it's kind of a hit or miss, whether they let me keep it or not, because it's a prepaid one. But
Once you get that set back up, then let the court know and let Ms. Hanu know your number, okay?
I will.
Now, this is a waiver of a preliminary hearing. So that means in a preliminary hearing, the state has the burden to prove a felony was probably committed. And you understand that?
Yep.
Do you understand that by waiving the right to a preliminary hearing, it means that you're agreeing that at least the state can meet that burden?
Okay.
Okay, you understand that?
Yep.
And at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, the officer who would be here to testify. She'd be able to produce other witnesses or evidence to testify and to have on your behalf. She would also be able to find out things about the case, and it could include defenses during this preliminary hearing. But for today's purposes only, you'd be waiving those rights. Do you understand that?
Yes.
Do you also understand that if the state does not meet its burden as to the preliminary hearing, that means that I could amend it to a misdemeanor or dismiss it altogether, but for today, you'd be giving up that right?
Yes.
And do you understand that once you give up the right for this hearing, it's forever and you can't get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling me you fully understand what you're doing?
Yes, Your Honor.
And voluntarily?
Yes, Your Honor.
All right, I'll find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Avila,
Thank you, Your Honor. I've gone through and filed the information. It mirrors the criminal complaint.
proceed with an arraignment or set for another date.
One moment, Your Honor. We will proceed with arraignment. We will not be exercising judicial substitution, and at this time, we will enter a not guilty plea.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Let's get a status date scheduled.
Your Honor, we would ask for a plea in sentencing.
Okay. Great.
And this is a Mr. Schmidt case, so wherever you can fit it in.
Oh, good. Okay. I can do 2 o'clock on May 18th, Monday, May 18th.
Your Honor, it is my birthday the day before. I will be out of town.
Okay. Let's do 10:30 on
This courtroom didn't just hand down a sentence. It handed down one final opportunity. Whether it's addiction, accountability, or rebuilding a life after devastating mistakes, the real judgment begins after the courtroom doors close. Do you think probation and treatment are enough to change someone's future, or should the justice system have gone further?
May 21st. I think I have you
I
right
have
before.
you-
Yeah, so
yes.
you can appear. I get what's more important for you to appear with. I said a sentencing, didn't I?
In Washburn,
Yes.
he'll be fine. That'll work. We'll figure it out.
Okay, or, I mean, you be with him and, oh, it's a plea and sentencing. I can't have you in two, I can be there with the Zoom, but I can't have you two places at once. What about 1:30 on May 20th?
I have a trial that day.
What about 1 o'clock on May 21st?
I'll make that work.
All right, May 21st at 1. You can come get your notice and you're free to go. Mr. Kokesh? I believe this is this a DJOC?
Yes, there is a misdemeanor that would be a plea and sentencing, but
We will go on the record in the matter 25 CF 175, State of Wisconsin versus Jared Kokesh. The state appears through Assistant District Attorney Jose Vila in person. Mr. Kokesh appears in person with his counsel, Emma Hanu. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Ms. Hanu, can you please recite it for the record?
yes, Your Honor, Mr. Kokesh would be entering a plea to count 1, suffocation and strangulation, for a deferred judgment of conviction agreement, of which I have the conditions and things that go with that outlined here in the document signed. He additionally would be pleading to count 2, battery, for 1 year of probation. Counts 3 and 4 would be dismissed and read in.
All right,
May I approach?
you may. Thank you. So, Mr. Kokesh, that's the agreement that you've reached.
Yes, Your Honor.
Mr. Vila and Ms. Bauer, Victims' Rights Compliance.
Yes, Your Honor.
So I have in front of me a plea questionnaire waiver of rights form, this document right here, and a deferred judgment of conviction document, that other document right here. Do you recognize both of those documents?
Yes, I do.
Did your attorney thoroughly go over both of those documents with you?
Yes, she did.
And you understand everything in those documents completely?
Yes, Your Honor.
I also have attached the jury instructions for the correlating charges. Did your attorney thoroughly go over the jury instructions, what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And did she go over the maximum possible penalties you face?
Yes, on that as well.
So you're pleading guilty to 1 misdemeanor count of battery and 1 felony count of strangulation, suffocation, correct?
Correct, yes.
You're 42 years old. You have 12 years of schooling. You can read, write, you understand the English language, all correct.
Yeah.
No mental illnesses or disorders?
No,
So no drugs, alcohol, or medications.
no.
Did you sign both of these documents at the appropriate spot?
Yes, I did.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of both of those documents. You're nodding your head up and down, so you remember that, correct?
Correct, yes.
Did your attorney thoroughly go over those rights with you,
Yes, she did.
and you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No, I think she did a fine job. I'm well aware.
Okay. And so do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, yes, I do.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, but,
I have to say that to everybody.
right.
Okay. And do you understand that one of the charges is a felony charge, but if the court accepts the agreement under the deferred judgment of conviction document, that felony won't be entered. Do you understand that?
Yes, I do.
And so unless a felony is, or if a felony is entered against you, do you understand that you would no longer be able to use or possess a firearm for life?
Yes, I do understand that.
And you wouldn't be able to vote in any election until your civil rights are restored?
Correct, yeah.
But that's only if that judgment gets entered for the felony. So you understand that?
Yes, correct.
Okay. With count one, strangulation and suffocation, does it have the domestic abuse modifier?
I don't have anything on the notes related to that, so I'm going to say no.
So no?
Let me check, Your Honor. It does, Your
Oh,
Honor.
it does. Yep, sorry.
Okay. Well, I knew it had the modifier. I just don't know if the agreement included removing
Yes.
it or not. Okay. And so do you understand with regards to count one, strangulation and suffocation, domestic abuse, that the state would have to prove on or around December 3rd, 2025 in Burnett County, Wisconsin, you intentionally impeded the normal breathing by applying pressure on the throat or neck of another person? Do you understand what the state would have to prove?
Yes, I do, Your Honor.
You understand that maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes, I'm aware of that too.
Do you also understand that upon conviction, if the court were to convict you of that, you could be facing the federal prohibition to no longer being able to use or possess a firearm?
Yeah,
And do you understand that upon conviction of that, you would also face an additional $100 surcharge?
yeah,
As to count two, the misdemeanor battery, domestic abuse, the state would have to prove on or around December 3rd, 2025 in Burnett County, Wisconsin, you caused bodily harm to LS by an act done with intent to cause bodily harm to that person without that person's consent. Do you understand what the state would have to prove?
yes, I do.
And do you understand that the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both?
Yes, I understand that as well.
Do you also understand that this has the domestic abuse modifier? That means upon conviction, it will have the potential to have a federal prohibition to no longer being able to use or possess a firearm for life?
Yeah,
And you, okay, for life. Okay, and so you understand that there is an agreement that you've reached with the state. You understand that?
correct, yes.
But do you understand that I'm not bound to follow that agreement?
Yes, I'm aware of that too.
I could sentence you to the maximum possible penalty if I thought that the facts warranted it. Do you understand that?
I do, Your Honor. I don't think that there's anything I need to hide or worry about. I trust you to do what you think is right.
I'm glad to hear you say that, Mr. Kokesh. Okay, so it means that I could sentence you to the maximum possible penalty if I thought it was warranted. But did you go over that criminal complaint with your attorney?
Yes,
And there's a section where it's called the probable cause section where it basically says what happened and why you were charged with these crimes.
yeah,
For the most part, are those facts accurate?
for the most part, what I read in the statement seemed to be at least their point of view of the matter.
Okay, so for the most part, they're accurate. Okay, has your attorney represented you competently?
Most definitely, Your Honor.
And she's answered all of your questions?
That and then some.
And you're satisfied with her services?
Absolutely.
And are you entering your plea freely and intelligently? That means you're telling me you fully understand what you're doing
Correct. Yes.
and voluntarily?
Yeah,
And no one's threatened you or promised you anything for you to plead here today?
no, Your Honor, nobody has.
Do you have any questions for the court or your attorney before we proceed?